Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she goes, oh, girl, you gotta hear this one. A man was arrested for running a theme park, and when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one.
All caps means you're either panicking or trying to represent yourself in court. Both are mistakes. Your feelings are adorable, but they're not admissible, persuasive, or even interesting without evidence. Yes, Heather hates immunity doctrines. It's a personality trait at this point. You don't need to remind her, she wakes up angry about it. Bring receipts. No, I heard it from so and so. This is quid pro quo, not next door. Screenshots are statutes only. Don't fight each other. Fight the law. It deserves it more. If you're offended, excellent. That means you're awake, paying attention, and probably new here. No diagnosing the host. She's petty, not pathological. And don't diagnose anyone else. Stay in your lane, please and thank you. Do not summon the mods. They're tired, hangry, and may bite when provoked. Disagree loudly if you must. The algorithm eats drama for breakfast. Just keep it cute while you argue wrongfully. If you're taking screenshots of my chat, touch grass, tell your handlers. I said hi and find a hobby that isn't me.
Hey everybody, happy Saturday. Go Navy, beat Army. I have to say it. It's required. If you're Navy, you know. If you're Army, well, stick around because I still like you, but not today. So anyway, today we're discussing a response to a motion that mentions something to exhibits and shit, but never actually posts the exhibits or attaches them or anything. And I in all of the years that I've been reading legal documents, I still never understand how one can refer to exhibits in a motion to dismiss and never actually attach any exhibits. There's no minor clerical error there. In federal court, you don't get to argue facts with imaginary paperwork. You either file it or you don't. The plaintiff's basically saying, and Randy is killing it with this one, You can't ask the judge to consider evidence that only exists in your imagination, because Lord knows everybody in this case has a creative fucking imagination. The filing also gets into full faith and credit, federal civil rights claims, and why immunity doesn't just magically apply because someone works for the state. So if you're here for vibes, sorry about your luck. If you're here for documents, facts, no spin, sorta no drama, and my sassy ass attitude, stick around because this motion might have torpedoed itself in its first page. How is everybody doing today? Uh, Gail, thanks for posting that. I appreciate it. There is some interesting things going on that channel. Thanks for everybody who hung out with me last night. Oh, that was a fucking hell of a stream. Um, for our legal chaos. Um, a little update to that stream last night. Dan Crenshaw, I don't know if I mentioned it last night. Dan Crenshaw has reached out to Sean Ryan and asked to come on his show and talk one-on-one. Should be an interesting fucking time. Holy hell. Holy hell. Holy hell. Debbie Webb, how are you? You are one of my favorite people right now because you gifted some memberships, I believe, on somebody else's stream, and them gifted memberships be exposing people. I'm just saying. Uh, Jeff, how are you? Good Saturday afternoon. Joan, hello on top. Ammo's girl, Elfie. Uh, who else is here? Is she Nemesis? As always, good to see you. Uh, this is the best intro for necessary information. I tried to keep it short today because I threw it together. I said I want to say this, this, and this, and this. Please make it make sense. Uh, it just still didn't make sense, but Snipe Hunter, Malin, good to see you. Faith says it all. I'm here for the sass. Yeah, appreciate you. Hey Squid, sorry dad duty called last night. No problem. Dad duty comes first. No hiding from the gifted gods. Yes, it was just funny. Girl, I didn't even give myself a heads up. I was like, you know what? I've got some time. I don't want to read this on Monday because I have other stuff I want to do on Monday. And um, um, it, Devil fan, the only thing that I ask on this channel is that we don't mention other channels, especially if I don't watch those channels. Y'all got a sense of what I watched last night when you could see what pops up on my side panel when I show you my YouTube screen. I don't um I don't really watch a lot of people, especially people talking about this case. I just don't. So you know, not to be rude, but um, you know, thanks drummer going to see TSO tomorrow. Have fun. I love them. That's like the only Christmas music I like. And Ninja Puppy, thank you so much for the Amazon wish list gift. That will be so helpful on a cold day in my closet floor. Um, thank you. It's appreciated very, very much. Yeah, who's rooting for Navy this afternoon? This girl. All right, so let's get into this document. All right. We're going to get through this as quickly as possible because it is 26 pages. So if I ignore y'all, sorry. And I know other streamers did get into this already, but guess what? I'm not them and I don't care. So if you could kindly, I have not read this all yet. So if you could kindly keep your, well, this person said this, or when I was watching it on so-and-so stream, they said this to yourselves. That's great and all, but I do my own thing here. I don't make content or read or make my opinions based on what other people said. Just because I'm me. And people have for some reason accused me of stealing content in the past from other people don't explain it. I have a whole channel that is related to something that has nothing to do with any of the people that accused me of stealing so I don't get it. But anyway, um, you know, with that being said, this is why one of the other reasons that I ask you not to tell me what goes on in other channels or what they said, because I don't really give two shits. Oh yeah, and it's the person who said that is a person that I no longer speak to, and she didn't start saying it until after I said, "Don't talk to me anymore." So, Squid odds on ASU coach coming to Michigan is plus 300. Yeah, well, that's about the odds for Georgia to win the Natty, so good luck. You're just not taking Alabama's coach because we like him here because we beat him. Plaintiff's response to opposition to defendant's motion to dismiss. And because this is 26 pages, I'm going to kind of skip some of the stuff that we already know. Randy submits this response in opposition to Daniel Rex Owens' motion to dismiss with prejudice. Defendant's motion suffers from fatal procedural defect that warrants denial. It repeatedly references and relies on Exhibits 1 through 3 to support factual assertions that contradict allegations in the complaint, yet these exhibits are not attached to the motion. And I looked back to make sure, and they aren't. Yeah, I have a whole channel that's that is devoted to information that came out of my own brain from my college degree. So yeah, a college degree that nobody else talking about this case has. Just saying. All right. And hey, Spawn, and hey, Captain, how are you? Sit in the back of the class. Yeah. I looked back at this motion because I read it and I was like, I think I mentioned it on when I read the motion to dismiss that these exhibits weren't, but like for some reason I thought that maybe he was going to attach it later, or I was missing something, or like in my brain it just didn't click. Um the and it now that Randy said it, it was like, oh, he never did upload those or amend that motion to dismiss. Holy crap. I was expecting like a someone to I was expecting, an amended motion to dismiss, maybe something like I just can't. This court cannot consider these phantom exhibits when ruling on a motion to dismiss under well-established 11th Circuit precedent. Even setting aside this defect, plaintiffs have adequately stated claims under 42 U.S. Code 1983 that should survive defendant's motion to dismiss. The complaint contains sufficient factual allegations that, when accepted as true and viewed in the light most favorable to plaintiffs, establish plausible claims for relief based on defendant's failure to give full faith and credit to valid protection orders as required by 2265. I'm going to stop saying 18 U.S. Code because it's the same. It's the criminal code. For violation of plaintiff's due process rights. Furthermore, defendant is not entitled to either absolute prosecutorial immunity or qualified immunity for the conduct alleged in the complaint. For these reasons, and more fully set forth below, defendant's motion should be denied. Factual background: we all know this by now. Just Oh, and hold on one second. I have to do one thing before before I get into this. I forgot to do something that in this video. Whee! I have to update something. There we go. Fair use. What about fair use? I don't know. I got nothing. I don't know what you're talking about. All right. So everybody knows what happened. Um, the state official employed by Florida allegedly refused to recognize the validity of their Ohio protection orders instead of initiating an investigation into whether the protected person, Plaintiff Hales, had committed the crime of perjury when obtaining the Ohio protection orders. The complaint alleges that the plaintiffs are protected persons under 2 valid orders of protection issued by the state of Ohio on or about October 30th, 2023, after a hearing in which the restrained parties, Lynette Preston and John Cook, had reasonable notice and opportunity to be heard. The complaint further alleges that when plaintiffs presented these protection orders to Levy County Sheriff's Office requesting enforcement, Defendant Owen refused to recognize their validity and instead investigated whether Plaintiff Hales, a protected person, had committed a crime of perjury in obtaining them. As alleged in the complaint, defendant's email to the Levy County Sheriff's Office dated October 30th, 2023 stated, "Can you email me the petition that Hales filed in order to obtain this order of protection? If you don't have a copy, please request one from the clerk of Summit County. I want to see if Hales committed perjury in the petition." This email was attached to the complaint as Exhibit 3. In November, the complaint or the exhibits that were actually attached to the motion. Hey, Paul. On November 21st, 2025, defendant filed a motion to dismiss with prejudice, arguing that he is absolutely immune from suit. Plaintiffs failed to state a claim upon which relief can be granted, and he is entitled to qualified immunity. Throughout his motion to dismiss, defendant repeatedly reinforces 3 purported exhibits to factually assert that purportedly contradict the allegations in the complaint. Specifically on page 2, defendant states Mr. Hales and Ms. Risk each reported violations of their protection orders to the Levy County Sheriff's Office and the 8th Judicial Circuit State Attorney and filed charges in Levy County cases, State v. Preston, that other case, State v. Cook. These phantom exhibits, despite these references, defendant failed to attach these purported exhibits to his motion to dismiss. Moreover, these unattached exhibits appear to contain information outside the 4 corners of the complaint that defendants relies upon to contradict plaintiff's allegations regarding his failure to enforce the protective orders. I mean, like, there's a lot of case law listed in this filing, so I believe Randy, yeah, just scanning it, there is a shit ton of case law. Honestly, I haven't looked at all the case law. I have not had the time to dissect it. However, there is a lot of case law. There we go. Summary: defendant's motion to dismiss should be denied for 3 primary reasons. First, motion improperly relies on unattached exhibits that cannot be considered by this court under 11th Circuit precedent. When ruling on a motion to dismiss, a court must generally limit its consideration to the pleadings and exhibits attached to them. The court only can rule on what it sees. It can't rule on what you said. It has to rule on what it sees. If it's not written down and the court doesn't see it, it technically doesn't exist. Defendant's unattached exhibits do not qualify for consideration under the incorporation by reference doctrine because they are not referenced in the complaint, not central to plaintiff's claims, and their authenticity cannot be verified. Second, even if the court disregards this procedural defect, plaintiffs have adequately stated claims under 42 U.S. Code 1983 that should survive a motion to dismiss. The complaint contains sufficient factual allegations that, when accepted as true, establish plausible claims for relief based on defendant's failure to give full faith and credit to a valid protection order as required by 2265 and for violation of plaintiff's due process rights. Third, defendant is not entitled to either absolute prosecutorial immunity or qualified immunity for the conduct alleged in the complaint. Defendant's conduct refusing to recognize a valid out-of-state protection orders and investigating whether the plaintiff Hales committed perjury constitutes investigative activity rather than prosecutorial function, for which only qualified immunity is available. Moreover, defendant's conduct violated clearly established federal law requiring states to accord full faith and credit protection to protection orders issued by other states. Defendant's motion to dismiss is improperly relies on unattached exhibits that cannot be considered by the court. Fatal procedural defect that warrants denial of the motion. Motion repeatedly references exhibits 1 through 3 to support factual assertions regarding state court cases allegedly filed in the restrained parties, but these exhibits are not attached to the motion. This court cannot consider phantom exhibits when ruling on defendant's motion. If you didn't attach them, they don't exist. And just because, and this is another case of the judge can't go searching. Just because you put the case numbers in the document, the judge really shouldn't be searching. You need to attach those exhibits, and then that gives him license to go search. He just can't go search just for the hell of searching because you mentioned some case numbers, because if he types in a case number wrong, for example, and finds something else, it's incidental, but it could be a problem. So, you gotta put the fucking information in there if you want it, you know? Hey. I just don't understand how you can file a motion to dismiss, and even if you say you uploaded it, you e-filed it, and you forgot, like, that should be an immediate, "Oh, crap, I forgot," and you amend it. Or you file it as a separate document and say, "These are the exhibits that go to that document." Why that wasn't done, I'm not sure. I can't even begin to get inside the head of that person. Legal standard, eh, when a lawyer hires a lawyer, you think they would do a good job at choosing a lawyer. Well, apparently he didn't do a good job. Legal standard for materials considered on a motion to dismiss. Under 11th Circuit precedent, when ruling on a motion to dismiss under 12b-6, a district court must generally limit its consideration to the pleadings and any exhibits attached to them. Baker v. City of Madison, 11th Circuit 2023. If the parties present and the court considers evidence outside the pleading, the motion to dismiss must be converted into a motion for summary judgment pursuant to FRCP 12D. Evans v. Rhodes, 11th Circuit 2018. The federal rules of civil procedure provide that a motion to dismiss shall be treated as a motion for summary judgment if the movement presents a matters outside of the pleadings. When a district court converts a motion to dismiss into one for summary judgment, the court is required to give notice to the parties and an opportunity for mutual discovery. Adnoff v. United Tech Corporation, 2014. 11th Circuit requires or recognizes a narrow exception to this rule under the incorporation by reference doctrine. Under this doctrine, a court may consider evidence attached to a motion to dismiss without converting the motion into one for summary judgment if 3 requirements are met. Plaintiff refers to certain documents in the complaint. Those documents are central to the plaintiff's claim, and the document's contents are undisputed, meaning their authenticity is not challenged. Johnson v. City of Atlanta. Here, there are no exhibits. That's a huge thing. That was a huge misstep. Huge misstep. I really think he's banking on immunity claims to cover his filings. I do too. People will try to hide behind immunity all the damn time. All the damn time. Um, like, hello. Um, People try to hide behind immunity way too much. Um, I don't like immunity. You saw in the rules. We're not going to get into how I feel about immunity because Lord knows, Lord knows we you know y- like I could go off on a 20-minute tangent on why immunity sucks, going back all the way to 1600, like the year 1607. Um, I could do a whole I could probably do a thesis right now for a master's program on why I hate um immunity doctrines. That's how much I hate immunity. That being said, we're uh we're going to move on. I just have to message somebody real quick. All right. I can beat you. I do 4 hour on tangent on squirrel. Wait, what was I talking? Yeah. Mm-hmm. 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 All right. While 11th Circuit and Crenshaw v. Lister held that when exhibits contradict the general and conclusory allegations of the pleading, the exhibits govern, this principle only applies to exhibits that are properly before the court, as those attached to the complaint or those that qualify under the incorporation by reference doctrine, which is also not the case here. Crenshaw, defendants' unattached exhibits cannot be considered under 11th Circuit precedent. Repeat the motion to dismiss repeatedly represents exhibits 1 through 3 to support factual assertions. These unattached exhibits fail to meet any of the requirements for consideration under 11th Circuit precedent. First, the unattached exhibits are not part of the pleadings. The Federal Rules of Civil Procedure provide that a copy of any written instrument which is an exhibit to a pleading is part thereof for all purposes. Rule 10. However, this provision is applicable to pleadings and not to motions. Defendant's unattached exhibits are not part of the pleadings and therefore cannot be considered on that basis. Interesting. Interesting. Second, the unattached exhibits do not qualify under the incorporation by reference doctrine. The 11th Circuit has consistently held that for a document to be considered under this doctrine, it must, one, referred in the complaint, two, central to the plaintiff's claim, and three, undisputed in terms of authenticity. Back to Johnson v. City of Atlanta, 2024. Defendants' unattached exhibits fail on all 3 counts. They are not referenced in plaintiff's complaint. They are not central to plaintiff's claims, and their authenticity cannot be verified because they are not even attached to the motion. I just have to laugh. That makes me laugh every time. Like, I know sometimes I can be easily freaking amused, but like when when you reference exhibits and you don't attach them, I can see making the mistake. Plain devil's advocate. I can see making the mistake. You've got a lot of cases. You've got a lot on your plate. You forget to upload stuff. Like, I forgot to upload something for my other channel and I put in the wrong date to release something. Totally can see that because I looked back and I'm like, why the hell did I do that? However, I fixed it once I saw it. Did they not go back and realize that they never attached the exhibits? Like, how is the judge supposed to make just heads will be rolling in that office and heads will be laughing in the judge's chambers. Like, the judge is probably like, "Y'all have to see this shit." This is one of the reasons that I'm not a judge because I would be like, "Y'all gotta read this shit. Am I losing it or is this shit ridiculous?" Ah, this is so good. I see Owens tripped himself up. Well, his lawyer tripped him up. Um, ah, snark, snark modding activated today. Don't mind the woman behind the curtain. I think Mr. Squid is making the little milkshake because I hear the. Oh nope, that's the bubble machine. It's bubbles, 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 bubble, bubble, bubbles. Quality work by taxpayer-funded staff. Remember, he is a lawyer. I'm not sure who his lawyer is as far as, like, what his position is. Probably another government employee, so um, yeah. He won't disqualify it, but he'll deny it. If it would have been disqualified already, it would have been disqualified already. Because there's a good chance the judge read it and was like, "I'm just waiting on a response in order to deny this." Oh, yes. I this is very well written. I like this because I was reading the other pleading, and I was on the fence about whether that pleading was going to be accepted, thinking that there was going to be motions or like exhibits. And when there was no exhibits, it was kind of like, okay, didn't think much of it because stupid me thought that, being a lawyer, they forgot to attach them. They would just amend or upload or e-file a separate document and say, our mistake, we uploaded a document without the attached exhibits. Here's the attached exhibits. And then when I got the notification that this was uploaded, I looked at it and I was like, oh, cool. Randy responded. And then I looked back at the other document because I always take a look at the other document before I've started to, because it's one of the things that's now in my brain to look back at the document that this is responding to. So I have a better idea of what's going on fresh in my memory. And I looked at it and I was like, where are the motions or where are the exhibits? I was like, where are the exhibits? And they just weren't there. And I'm like, they never up. And then I read the first page of Randy's motion and I'm like, well, damn. Well, damn. I ain't scared of no mods. The mm, mm, this right here. This right here. Yeah, we were so focused and angry about the immunity issue that it was like, it ah, eesh. Well, I hope this at least moves the case into discovery because I think I'm still not sure if I'm still not sure about the immunity issue. We'll we'll get into more about Randy's thoughts and the case law, but there's always this thing of like I'm never really sure what way a judge is going to go on immunity because immunity people hide behind it all the time. It but I'm hoping this will at least reassure everybody that it will go to discovery because discovery is a bitch. And as we read in the response to Dan Crenshaw's cease and desist letter against Sean Ryan last night, discovery can be enlightening in so many. If you haven't caught my stream from last night, I dived into 5 cases. I started with Lips's text messages on the day she was served by ABC Legal. But we got into some funny, some what the hell, some sad. Um, but we did discuss a cease and desist letter where they talked about discovery. So discovery is it pulls all the shit out of the closet. So only 42 likes. Can we get that number of likes up, please? Please. Oh no. 40 well, I have 41 likes. squid, but no nastiness. Well, let's see. My chat, uh, my studio is messed up today. I don't know why. Like my live control room is just not wanting to work. Let's see. I'm gonna have to mute myself for just a second so I don't echo. Oh. Oh, that's why. Never mind. All right. Yeah, I hit my nasty fill of PDFs for the day or the week. Yeah, discovery is a bitch, sister of karma to many. Yeah, karma is slow. Uh, the wheels of karma, just like the wheels of justice, turn slowly, but Lady Karma always keeps receipts. Um, as we've figured out recently, Karma does not forget. She has her long-term memory is impeccable. All right. 11th Circuit emphasized that a document need not physically be attached to a pleading to be incorporated by a referent into it if the document's contents are alleged in a complaint and no party questions those contents. We may consider such a document provided it meets such centrality requirement. It meets the centrality requirement. Davy Taylor. Here, however, the unattached exhibits are not alleged in the complaint, and their contents are not even before the court for authentication or verification. Consideration of unattached exhibits would require conversion to summary judgment. If this court were to consider defendants' unattached exhibits, it would be required to convert the motion to dismiss into a motion for summary judgment. FRCP 12D provides that a motion to dismiss shall be treated as a motion for summary judgment if the movement prevents matters outside the pleadings. When a district court converts a motion to dismiss into one for summary judgment, the court is required to give notice to the parties and opportunity for mutual discovery. 11th Circuit has strictly enforced this requirement in SFM Holdings Limited v. Bank of America Securities LLC. The court held that if a district court considers materials outside of the complaint, it must generally convert a motion to dismiss into a summary judgment motion, opening them up to discovery. And as we've figured out, discovery is a big old big old bitch. Kind of like me. Such a conversation or such a conversion requires notice to the parties and an opportunity for mutual discovery. CF Anadolph v. United Tech Corp. 11th Circuit 2014. Critically, such a conversion requires notice to the parties and an opportunity for mutual discovery. Failure to provide such notice and opportunity constitutes reversible error. Trustmark Insurance Company v. ESLU 2002. This is a lot of case law, and it's all 11th Circuit. I mean, which is good. Moreover, 11th Circuit has cautioned against premature conversion of motions to dismiss into motions for summary judgment, noting that such conversions should not be used as platforms for pseudo-summary judgment motions at a time when the case is not at issue and the parties have not engaged in reciprocal discovery. Back to the United Tech Corp. The Supreme Court has similarly frowned upon court-imposed heightened pleading standards designed to weed out non-meritorious claims before discovery. In citing Leatherman v. Tarrant County Narcotics Intelligence Coordination Unit. Defendant's reliance on unattached exhibits constitutes an implicit admission that the complaint states plausible claims. Defendant's reliance on unattached exhibits constitutes an implicit admission that plaintiff's complaint states a plausible claim that cannot be defeated without going beyond the pleadings. That's a good point. That's like, why are you trying to hide behind immunity if you don't think you did anything wrong? Just a under U.S.C.S. FRCP 8, a complainant must contain a sufficient factual matter accepted as true to state a claim of relief that is plausible on its face. Everybody's favorite case, Ashcroft v. Iqbal. I feel like every motion I've read in the past year has had that. Unfortunately not. Unfortunately not. I there's and this is the difference between what I think should happen and what I think is actually going to happen. You know, I hope Florida ends up paying here. They could have stopped this day one. Yeah, they could have. They could have. I mean, they could have. I think this filing sounds like Doreen. Just a guess. Doreen could teach a master class in snark. Yeah, that's yeah. So could that lawyer from last night. That lawyer who wrote the Sean Ryan response. She could write a master class in snark as well. Yeah. A claim that has facial plausibility when the plaintiff pleads factual content that allows the court to draw reasonable inference that a defendant is liable for the misconduct alleged. By relying on unattached exhibits to support his motion to dismiss, Defendant Owen effectively concedes that a complaint on its face states a plausible claim for relief. This is because if the complaint truly failed to state a claim upon which relief could be granted, Defendant Owen would have no need to rely on external evidence. The fact that Defendant Owen feels compelled to reference external exhibits implies and reasonably infers that the complaint meets the plausibility standard required to survive a motion to dismiss. Yeah. Furthermore, defendant attempts to introduce factual assertions through unattached exhibits. You got a 1-2? A 1-2 in our house is a Swiss cake roll because she wants one too. Sorry, I lost my place. Apologies. All right. All right. Furthermore, defendant's attempt to introduce factual assertions through unattached exhibits runs counter to the purpose of Rule 12b6 motion, which is the test the legal sufficiency of the complaint, not to resolve factual disputes. Defendant's attempt to introduce factual assertions without properly attaching the supporting exhibits is an improper attempt to circumvent this rule. Plaintiffs have adequately stated a claim or stated claims that should survive a motion to dismiss. Even setting aside the procedural defect regarding Defendant Owen's phantom exhibits, I really like how it's italicized, like phantom exhibits. Just saying. Plaintiffs have adequately stated claims under 1983 that should survive defendant's motion to dismiss. The legal standard for 12b6, when evaluating a motion to dismiss under Rule 12b6, the court must accept a well-pleaded fact as true and draw all reasonable inferences in favor of the non-moving party. That's fair. Dusak v. J.P. Morgan Chase, 11th Circuit, 2016. The court considers facts alleged in the complaint and any exhibits attached to it. Thornton v. Ipsen Biopharmaceuticals, First Circuit, 2025. Ooh, that might be a good case to look at. Wait, what? Oh boy. Y'all crack me up. Uh, when does this case go to court? Not anytime soon. The judge hasn't ruled on any of this stuff yet and hasn't set a date for anything. Um, I couldn't begin to tell you. Uh, a complete complaint need not contain detailed factual allegations, but it must provide more than an unadorned "the defendant unlawfully harmed me" accusation. Yeah, you have to have some sort of something, but you don't have to provide you don't have to lay all your cards on the table, but it has to be plausible. Middle District of Florida, November 3rd, 2025. Ooh, recent case. Interesting. Super interesting. As shown above, to survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim for relief that is plausible on its face, and a claim has facial plausibility when a plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the misconduct alleged. Ashcroft v. Iqbal. You can keep that up there. One of my friends here went to North Carolina for a tournament for one of her children, and she said it was snowing, and it's like, please don't bring that home with you. Please, 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 please keep it there. It's like 58 degrees here. It's not awfully cold. Plaintiff's first claim, failure to give full faith and credit. 2265 creates a federal right enforceable through 1983. Section 1983 provides, all I saw was this, and I have no idea what you guys are talking about. This is where it's like you just gotta ignore the chat because I have no idea what y'all are what's going on with y'all, and like, ugh. Please don't break me. I'm doing a pretty good job of staying on topic today. So, we're already on page 12 and we're only 47 minutes into this thing. We didn't do too bad. Uh, plus, I got to get to the football game, so I got to be done by 3. I think I know what you're talking about, but I'm not sure. So I'm just gonna, yeah. I, I never know what you're talking about. You got so much going on in that weird little brain of yours. And, 1983 provides a remedy for the deprivation of rights, privileges, or immunities secured by the Constitution and laws by persons acting under the color of state law. Full faith and credit provision for protection orders, codified at 18 U.S. Code 2265, establishes that protection orders issued by one state shall be accorded full faith and credit by the court of another state, Indian tribe, or territory, and must be, quote, enforced by the court and law enforcement personnel of the other state, Indian tribal government, or territory, as if it were the order of the enforcing state, Indian tribe, or territory. The statutory language creates a clear federal right to have protection orders recognized and enforced across state lines. The complaint adequately alleges a violation of this right. The complaint alleges that defendant Owen, acting under color of state law as a Florida state official, refused to recognize and enforce facially valid protection orders issued by the state of Ohio. Instead of enforcing these orders as if they were the order of the enforcing state, as required by 2265, Owen questioned the validity of the 2 valid protection orders issued by the state of Ohio, and in an utterly shocking manner tried to turn the tables on Article 4, Section 1 of the Constitution itself by ignoring the Ohio protective orders and by investigating whether the victim, Plaintiff Hales, had committed a crime perjury when obtaining the protection orders in Ohio. I even like the exclamation point. The complaint specifically alleges that defendant Owen requested to see something beyond the 2 valid protection orders issued by the state of Ohio. He asked to see the petition for a protective order that Hales filed in Ohio to obtain the protection order, stating he wanted to see if Hales committed perjury in the petition. I don't know, because Ohio doesn't make, well, one, because protection orders are generally sealed because they're protection orders. So we won't see them unless somebody leaks them. I don't know what the orders are. So there, I have no idea. If it was mentioned to the judge up there in a motion of filing something like that, then possibly. But if it was never mentioned to him in any filing by Jeremy's attorney, then probably not. Because remember, the judge can't do outside research. The judge can never do outside research on either party. He can only go off, or she can only go off of what is in the filings. This is where you nearly had a brain crash out. Well, Spawn Trooper, I'm half Finnish and half Swedish, so do better. Okay. I'm a quarter Finnish. My grandpa was the product of Finnish immigrants. All right. Even though that might be within his purview, I would never do that. Yeah, there is judicial the code of judicial conduct basically doesn't allow judges to do outside research. And that was a big contention point on my channel a lot when people were like, the judge in the other federal cases people were like, the judge should just research Lynette and John. He literally can't. And it was like, he literally can't. And neither can any other judge. It's not limited to Beletho and Lynette and John. It's like, you just can't. It creates an ethical issue. So, hey, screenshot this. Yep. Whoop. And Palmer's Archer. Hey, thanks for being a member for a year. Woo! The haters didn't wreck us. My haters just fuel me. Kind of like Silver Fox put in the Discord the other day. A meme a Georgia Bulldog meme that says fueled by haters. I'm like, yep, because when people tell me I can't do something or I shouldn't do something, it just makes me want to do better and do more. So I love when people like tell me what I can and can't talk about. I'm like, oh, now I'm just going to talk about it more and I'm just going to do a better job because why not? Yeah. It's just funny though. Hate Squid all you want, to makes her stronger. No, I was just talking to somebody earlier today about certain things and certain things going on and certain people flipping out about certain other people. And a certain person that shall remain lipless, or yeah, you know who I'm referring to. I'm like, what's interesting is she's obsessed with one person and really one person only. But like, I've mentioned her too, and she has yet to mention me. I'm like, interesting. Like, not that I want to be mentioned, but it's like, what you scared of, lady? What you scared of? hmm Just saying. All right. Defendant Owen's conduct, including ignoring the Ohio protective orders, directly contravenes the mandates of the U.S. Constitution and the statutory requirement that protection orders be given full faith and credit without such a re-examination. Hey, Roy. His immunity doesn't cover his investigative aspect, and this is where it got interesting. Under 18 U.S. Code 2265, a protection order from another state must be enforced as long as the issuing court had jurisdiction over the parties and matter under the law of that state, and a reasonable notice and opportunity to be heard was given to the person against whom the order was issued. The statute does not permit officials in the enforcing state to investigate the truthfulness of statements made in obtaining the original protection order. The result of Owen's acts was a complete 180 from the standpoint of Levy County law enforcement. Defendant Owen's inquiry into whether or not the protected person, Mr. Hales, committed the criminal act of perjury had a chilling effect on any attempt by Levy County law enforcement to proceed with analyzing whether or not there was probable cause to arrest the Ohio respondents for violating the Ohio protective orders. And this was a timeline question that I was thinking about. In Owen's motion to dismiss, when he mentioned those 3 cases and he said that he was going to put exhibits and obviously never did, what were the dates of those compared to when the date of Jeremy's email, or not Jeremy's email, but his email to the Levy County Sheriff about Jeremy committing perjury or alleged perjury? It's one of those situations where it was like, I don't know the timeline. So looking at the timeline would be like, yeah, okay, it has a chilling effect because they were enforcing it before. So Dan Owen saying in his motion to dismiss, well, they filed 3 cases against him. Well, that was before you stuck your nose in. It had a chilling effect on any attempt by Levy County law enforcement to proceed with analyzing whether or not there was probable cause to arrest the Ohio respondents for violating the Ohio protective orders. Regarding defendant Owen's claims, the Florida Enforcement of Foreign Judgments Act must also be considered. This is absolutely contradicted by none other than the Attorney General for the state of Florida himself. Florida Attorney General Opinion Number 96-71, issued in September of 1996, states the provisions of state laws, such as the Enforcement of Foreign Judgments Act, are inapplicable to the enforcement of a foreign protection order issued in compliance with the VAWA. A Florida Attorney General Opinion Number 96-71 addresses the enforcement of a foreign protection orders under the Violence Against Women Act. It states that foreign protection orders issued in accordance with 2265 are enforceable by local law enforcement agencies in Florida without the need for registration or recording. The opinion emphasizes that such orders must be enforced if they were issued by the enforcing state, provided the issuing state had both personal and subject matter jurisdiction. JKD Buck, where are you? Grounds, and the respondent received reasonable notice and an opportunity to be heard. Freaking sucks. Owens also disregarded the Florida Attorney Directive that said all protection orders must be enforced. Yep, there we go. I knew it was coming. Because it always does. Every time subject matter jurisdiction is stated in any case, in any filing, in any court hearing ever, and you're there, there's the next comment is always grounds. All right. With the enactment of the Violence Against Women Act of 1994, Congress has recognized that domestic violence constitutes a national problem that transcends state lines. The act provides a critical component in the protection against domestic violence by mandating the recognition and enforcement of foreign protection orders. Title 18 U.S. Code Statute 2265A provides any protection order issued that is consistent with subsection B of this section by a court of one state or Indian tribe the issuing state or Indian tribe shall be accorded full faith and credit by the court of another state or tribe, the enforcing state or tribe, and enforced as if it were the order of the enforcing state or tribe. In order for the full faith and credit provisions to apply, the Act requires that the state issuing the protection order have both personal and subject matter jurisdiction, and that the respondent receive reasonable notice and an opportunity to be heard. And they were. Hey, EMS for life. Owens is arguing his own policy. A protection order is defined in 18 U.S. Code 2266 as including any injunction or other order issued for the purpose of preventing violent or threatening acts or harassment or contact or communication with or physical proximity to another person, including temporary and final orders issued by civil or criminal courts other than support or child custody orders, whether obtained by filing an independent action or as a pendent light order in another proceeding, as so long as any civil order was issued in response to a complaint, petition, or motion filed by or on behalf of a person seeking protection. Holy run-on sentence. And Palmer's Archer Home said, thanks for the $10 super chat. Sweet little baby squids orthodontia fund. They don't know what they have unleashed. You bet that Levy County is under the microscope now. I believe all the corruption will be exposed. Fuck around and find out. I believe it will be exposed, but here's the problem. Exposing it is one thing. Doing something about it to change it is completely different. I believe it will be exposed. I do not believe anything will change. That's it's my what I it's what I want to happen. I want all this shit to be exposed because there's the good old boys club exists here too. It's just one of them situations where like uh what you want to happen and what will happen are two different things. A review of the legislative history surrounding the enactment of Violence Against Women Act indicates an intent to provide protection for victims of domestic violence crimes across state lines. A congressional committee report discussing the act stated that the Violence Against Women Act makes protective orders issued by one state good in the other 49 states. Under then current law, a spouse who obtains a stay-away order in one state may lose the protection of that order if she crosses state lines. The committee believes these actions to constitute an appropriate response to the problem of domestic violence, which, because of their interstate nature, transcend the abilities of state law enforcement agencies. Thus, is not a radical expansion of the state law to require one state to enforce the stay-away order of another. Its fundamental rule of law. It is a fundamental rule of law that statutes are to be construed to give an effect to the intention of the legislative body. Thus, in order to give effect to the expressed intent of the Congress, I am of the opinion that the Violence Against Women Act requires that a protection order issued by another state or Indian tribe, in accordance with the provisions of 18 U.S. Code 2265, be treated and enforced as if it were a protection order issued by a Florida court. Article 4, Section 1 of the United States Constitution provides full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. The provisions of 2265 constitute an implementation of the authority granted to Congress by Article 4, Section 1 of the Constitution. Congress has specified that the protection orders of one state, consistent with the provisions of the Violence Against Women Act, are to be enforced in any other state, as they should be. Like, there are just certain things that, like, I agree with this, that just transcend state lines. Like, I personally know of a situation right now of a family in Ohio that fled to a different state, um, to get away from a certain individual, and that person went back. So we're still trying to figure out what's gonna happen there, but that's beside the point. So if you're the praying type, pray for some, just throw up a couple prayers for some people I know, um, because she went back to the person that she was trying to get away from. So we'll see what happens. Hopefully, it's not bad news. The federal act does not make such enforcement contingent upon registration in the enforcing state or require judicial review prior to the enforcement of the foreign domestic violence protection order by law enforcement. Well, that's where she fled from. So that's where she went back to. So, you know. Ordinarily, in Florida, an individual wishing to enforce a foreign judgment must record the judgment with the clerk of the circuit court. Under the Florida Act, notice must be provided to the individual act against whom the judgment applies, and such judgment is not enforceable for 30 days after the mailing of notice by the clerk. If the provisions of the Florida Act were applied, the target of the order would be notified of the filing by and the location of the DV victim, which would hinder the victim's ability to keep her location secret, which is kind of the point of fleeing. Ugh. I- As noted above, nothing in the Violence Against Women Act requires registration of foreign protection orders in the enforcing state. While there may be advantages in registering such orders, requiring registration could leave victims unprotected and vulnerable from the time they enter a new state until the time they become aware of and satisfy registration requirements. The federal act preempts any registration requirements by mandating any foreign domestic violence protection be enforced as if it were an order of the court of the enforcing state. Thus, the provisions of state law, such as the Enforcement of Foreign Judgment Acts, are inapplicable to the enforcement of the foreign protection order issued in compliance with the Violence Against Women Act. In Florida, a temporary or final judgment or on an injunction for protection against DV is valid and enforceable in all counties of the state. Law enforcement officers are authorized to use their arrest powers under Section 901.156 Florida statutes to enforce a DV injunction. Therefore, in accordance with the mandate that foreign protection orders issued in accordance with Violence Against Women Act be given full faith and credit and enforced in the same manner as state protective orders. I am of the opinion that local law enforcement officers should enforce foreign protection orders as if they were an order of the court of this state. Such orders, like state DV injunctions, are enforceable throughout the state. While legislative action to clarify these issues may be helpful, enforcement of foreign protection orders is not contingent upon the passage of such legislation. That was fire. I mean, that was fire. Like, read the part about the police again. Um, Law enforcement officers are authorized to use their arrest powers under Section 901.156. So, that was all the way. That was what, 30 years ago, 31 years ago. Plaintiff's second claim, violation of substantive due process rights. Allegations in the complaint point to failings on the part of defendant Owen by inter alia ignoring the Ohio orders altogether since questioned how they were obtained. Plaintiffs have not alleged procedural deficiencies in the process used to deprive their interest, if any, in the enforcement of the Ohio orders. This means that their claim is best considered irrespective of process, as a deprivation of substantive due process right. by ignoring the validity of the Ohio protection orders and instead initiating an investigation into the truthfulness of Plaintiff Hale's statements in obtaining these orders, Owen effectively nullified the protection orders without any process whatsoever. I just, you know, this is whoever wrote this, whether it was Randy or Doreen, this is freaking awesome. It is important to note that while the Supreme Court has held that individuals generally do not have a constitutional right to have someone else arrested for a crime, this principle does not apply to protection orders that are ignored. This is deliberate indifference towards the violation of an individual's constitutional rights. They're not only shutting down or explaining their case, but they're also shutting down possible rebuttals to their points in the next sentence. It's fucking amazing. Substantive due process rights are by ignoring the protection orders rather than enforcing them. Defendant Owen violated this clear statutory mandate. Substantive, I hate that word, due process protects individuals from prescribed deprivations of life, liberty, and property, no matter the process employed by the state. See, Madden, substantive due process is a source of rights which may not be taken away under any circumstances. This is not a case where the alleged violation is simply that an order was issued and law enforcement ignored calls to arrest someone. Rather, the defendant, Owen, affirmatively and deliberately chose to ignore facially valid Ohio protection orders. In these circumstances, defendant Owen's inactions with regard to the Ohio order means that this court can easily infer from the facts alleged that defendant Owen was aware that Mr. Cook and Ms. Preston posed a significant risk of harm to plaintiffs vis-a-vis his knowledge of the orders, yet he acted indifferently to that risk by choosing not to act at all regarding the Ohio orders, other than investigating whether Mr. Hales committed perjury. Oh. Whitley v. Hanna, 5th Circuit 2013, citing Doe v. Taylor Independent School District, 5th Circuit 1994. An omission that evinces deliberate indifference towards the violation of an individual's constitutional rights may amount to an act that causes the violation. Atterbury, Nakona General Hospital, 5th Circuit 2005, holding that plaintiffs sufficiently pled deliberate indifference against two superiors who, although they could have investigated the complaints, they did nothing for a considerable period of time. I'm loving this. I'm loving this. This came out last night when I was live talking about all of our other craziness for the week. And I just decided not to wait until Monday because one, I have other stuff. Something else will probably pop off before Monday. And Monday will be other things to discuss. So I wanted to get this out of the way. And we're in between regular season football and the playoffs, and it's Army Navy Day, so the game's not till 3. I got time. Oh, all right. Here we go. Defendant Owen argues that he's entitled to absolute immunity as prosecutor. I'm going to try not to if you see my blood pressure rise every time I say the word immunity, just mind your business and hit the like button. Because we all know how I feel about immunity. He's entitled to absolute immunity as a prosecutor. However, this argument fails because investigating whether Plaintiff Hales committed perjury in obtaining a protection order is an investigative function, not a prosecutorial one. Prosecutors have only qualified immunity where performing functions not associated with their role as advocates for the state. The actions of a prosecutor are not absolutely immune merely because they are performed by a prosecutor. Buckley v. Fitzsimmons, Supreme Court, 1993. In Buckley, the Supreme Court emphasized that a prosecutor is not an advocate before probable cause exists, that investigative functions, such as searching for evidence or corroboration, are not entitled to absolute immunity. The Supreme Court could not have been clearer. Prosecutors are not entitled to absolute immunity for their actions in giving legal advice to the police. I mean, mm. That means that Owen's investigative actions, such as advising the Levy County Sheriff that Owen need to evaluate the validity of a foreign protection order because he suspected the protected party had committed perjury in obtaining the protective order before any judicial proceedings began, falls outside the scope of absolute immunity and instead subject to qualified immunity. Mr. Owen's inquiry into the merits of a foreign protection order under the Violence Against Women Act, absent a specific violation, is an investigative act and would generally be protected by qualified immunity rather than absolute immunity. The 11th Circuit amplifies the Supreme Court on this issue. Ooh, you got the Supreme Court and the 11th Circuit agreeing. Ooh. On the other hand, prosecutorial immunity does not apply when the prosecutor acts outside the ambit of activities intimately associated with the judicial process. Generally, the Supreme Court has made clear prosecutorial immunity may not apply when a prosecutor is not acting as an officer of the court, but is instead engaged in certain investigative or administrative tasks. Van de Kamp, Supreme Court at 861. These activities include conducting investigative work before an arrest, making statements to the press, and providing legal advice to police regarding a pre-indictment investigation technique. And Hart v. Hodges, 11th Circuit, 2009. Oy. Defendant is not entitled to either absolute prosecutorial or immunity or qualified immunity. Prosecutors enjoy an absolute immunity only for activities intimately associated with the judicial phase of the criminal process. This immunity extends to prosecutors' acts undertaken in preparing for the initiation of judicial proceedings or for trial, and which occur in the course of his role as an advocate for the state. I'm loving this, sorry. A prosecutor enjoys absolute immunity from allegations stemming from the prosecutor's functions as an advocate, but has only qualified immunity when performing a function that is not associated with his role as an advocate for the state. And we're on page 22, and we're only an hour and 17 minutes into this stream. It's a good motion when you're not going constantly stopping and going, what the hell is this? What the hell is this? You're only stopping to go, that's a really good point, or mention something that was brought up before, or agree. It's a really good motion when it's an easy read. Like, we're not having to stop every 5 seconds and go, what the hell is this? Like, yeah, Randy quoted Supreme Court cases. Damn it, that's not a sledgehammer to it. Well, Randy not only quoted Supreme Court cases, he quoted the 11th Circuit, reinforcing and quoting the Supreme Court. It's like a double whammy. It's like, here's the Supreme Court case, but here's also the 11th Circuit later agreeing with the Supreme Court. Now it's a twofold. Yeah, this is one of the best readings in a long time. Like, yeah, this is the conduct alleged in the complaint, refusing to recognize the validity of the protection orders issued by an Ohio court and investigating whether Plaintiff Hales had been truthful when obtaining those orders, falls squarely within the category of investigative activities for which the prosecutors receive only qualified immunity. Defendant Owen's email explicitly states his intentions to investigate whether Plaintiff Hales committed perjury in his petition for a protection order. In my opinion, it would have been a little different if he reached out to the Ohio clerk on his own and I'm not saying I'm still not agreeing or saying that it would have been right, but the fact that he involved the police and he had the Levy County Sheriff's Office reach out to the Summit County clerk, that was an extra step that, like, didn't need to happen. Like, that was an extra step that, like, made it even more sus than it already was, if you know what I mean. Like, I'm not saying that him reaching out would have been appropriate either. However, when he involved the Levy County Sheriff's Office and got that third party involved, that wasn't yeah. Oh, yes. Oh, I agree. But that email to the Levy County Sheriffs would not have existed. And it would not if that would not have existed, that would not be an exhibit in Randy's initial complaint. It would be one less piece of evidence against him. My point. You know? It's yeah, that's probably not the last email they have too, but that email would have been one less piece of evidence. Mm. And how many times do we say if you're gonna be stupid and commit a crime and do something you're not supposed to, don't put it in writing? Don't put it in writing? Like, ugh. This investigative function is not entitled to absolute immunity under well-established precedent. Similarly, in the 11th Circuit, when a prosecutor obtains and reviews suspects' public driver's license records, such conduct may be properly characterized as investigative rather than prosecutorial. Y- Yeah, that's not, stay in your lane. Defendant Owen was not acting as an advocate for the state in a judicial proceeding, but rather was investigating potential perjury. Defendant Owen concedes he was only investigating. Mr. Owen sent an email to the Levy County Sheriff's Office that shows he was investigating the Ohio court's jurisdiction over the restrained parties. It's just, it's just bad. It's just bad. Um, any idea when the judge will rule? Rumor is asking Randy to allow reference exhibits. I wouldn't, but I'm petty like Squid. I wouldn't either. Like, I I'd be like, you didn't put him in there. You want to hide behind immunity, and you want to hide behind a procedural issue or a procedural thing like immunity. Um, and now you didn't. It would be different if it was like truly like a case law thing, like a, hey, we messed up this case law, or I put the wrong reference in. I meant to do this, and it had been a communication between Dan Owen's lawyer and Randy. However, when you do something as stupid, you're hiding behind immunity, and you do something as stupid as referenced exhibits, but forget to attach those exhibits, my petty ass would be like, "Oh, hell no. No, no, no. No, no, no. This is not something that it was like it is a simple mistake. This is like that's intentional. That's either intentional or pure stupidity. Either one of which mm, is just yeah, Owen should learn to stay in his own lane. There's two things that are free in life: the ability to mind your own business and stay in your own damn lane. And he apparently has neither. You know? Defendant Owens requested for the petition filed by plaintiff Hales to determine if he committed perjury as an investigative function. The email demonstrates that defendant Owen was not acting as an advocate in an ongoing judicial proceeding. Not entitled to qualified immunity. Even if defendant Owen is not entitled to absolute immunity, he argues that he is protected by qualified immunity. This argument also fails. Qualified immunity shields government officials from liability only when their conduct does not violate clear established statutory or constitutional rights of which a reasonable person would have known. I mean, oh, Taylor versus oh, y'all, look at this. Okay, so this case law. Look at this. We're gonna look up this case shortly thereafter. We're gonna look up this case because we got some. We're gonna have an extra little bit of time here. So I like to cap these at 2 hours, but we're gonna look up that because that was Taylor versus Levy County Sheriff's Office, Northern District of Florida, May 29th, 2025. Defendant Owen's refusal to recognize the validity of protection orders issued by an Ohio court and ignoring the same violates clearly established federal law. Under federal law, any protection order issued or any protection order issued that is consistent with subsection B of this section by the court of one state, Indian tribe, or territory shall be accorded full faith and credit by the court of another state, Indian tribe, or territory, and enforced by the court and law enforcement personnel of the other state, Indian tribal government, or territory as if it were the order of the enforcing state. 18 U.S. Code 2265 at A. Full faith and credit clause and its implementing statute require states to respect and enforce the valid judgments of other states, and certainly not ignore them. This means that a reasonable official in Defendant Owen's position would have known that refusing to recognize a valid out-of-state protection orders violated federal law. Federal statute clearly mandates that protection orders issued by one state must be accorded full faith and credit by other states. This is not a novel or ambiguous legal principle, but rather a well-established requirement under federal law. Yeah, most people in the chat knew that that was a thing. They know that there's exceptions to it. I mean, but at the same time, like, it was a general, like, when you cross state lines, yeah, you still have your shit's still valid. Mind your own business and stay in your own damn lane. Merch, coffee mugs, t-shirts, and keychains coming to the Squid store spring 2026. Yeah. I've said that for years. It's like somebody had told me that maybe I think when I was like 20, maybe when I was still a teenager. And it was like there was two things that are free in life: the ability to stay in your lane and mind your own damn business. They had literally said, I highly suggest you do both. So for the most part, I have my exceptions because sometimes I'm a nosy bitch. I do. I just stay in my lane, you know? Just stay in my lane. Just mm. So I feel like this guy was playing loose with immunity. He might get away with it. The problem with immunity, especially when you're in like a good old boys county, is the judge. But we'll see how this goes because this is a federal judge. We'll see. You think you found a new rabbit hole to jump in? Yay, a new project. Which yeah. Hey, freckled. Yes, and that's the other thing. Like, one thing that I stress on this channel is I hate people thinking they're above the law, whether that be a politician, whether that be a member of the community, whether that be a YouTuber, anybody. Like, oh, a federal magistrate actually from Ohio. Oh, I didn't realize he was from Ohio. We'll see. Um, yeah, I understand that immunity has a place, a specific purpose for specific things, like judicial immunity, not being sued by a say this case goes to trial and one party obviously is going to lose. Um, then that party can't sue the judge because they lost. That's where judicial immunity would be appropriate because that's its original intention. You can't lose a criminal case and sue the judge because you lost your case. It's just that is where judicial immunity is appropriate. That is where prosecutorial immunity is appropriate. You can't sue the prosecutor because you lost your criminal case because he beat you. It it has a very fine line. I do not believe in absolute immunity for anybody. Ugh. Yeah. It's like, this is not a novel or ambiguous legal principle. It's not new. Most people in chat knew it. Furthermore, defendant Owen's investigation into whether plaintiff Hales committed perjury when obtaining the protection orders exceeds his authority. If Owen had concerns about the validity of the protection orders, the proper course would have been to challenge them through established legal channels, not to refuse to ignore them and launch an independent investigation into potential perjury. There's proper legal channels for that, and being, the county attorney and uh, being a fucking lawyer, you should know. I don't exactly know the proper legal channels, but hell, I'm not a fucking lawyer. Mm, Hello. Thanks to all the lurkers for hanging out and commenting. Jesus. Conclusion. For the foregoing reasons, defendant's motion to dismiss should be denied. Defendant's motion improperly relies on unattached exhibits. I have to laugh every time I say that because you're either like you thought you were above everything and you could get away with crap like that, or you're just really fucking stupid. Like that cannot be considered by this court under well-established 11th Circuit precedent. Even if the court were to disregard the procedural defect, plaintiffs have adequately stated under or claims under 48 or 42 U.S. Code 1983 that should survive a motion to dismiss. The complaint contains sufficient factual allegations that, when accepted as true and viewed in the light most favorable to defendants, establish plausible claims for relief based on defendants' failure to give full faith and credit to valid protection orders as required by 2265, and for violations of due process rights. Furthermore, defendant is not entitled to either absolute prosecutorial immunity or qualified immunity for the conduct alleged in the complaint. Plaintiff's claims are well pleaded and supported by sufficient factual allegations to survive a motion to dismiss under Rule 12b-6. Say 12b-6 one more damn time. Sorry. Ugh. Ugh. I liked him up until that point. That said, the court should grant Owen's motion. Should the court grant Owen's motion, it should do so without prejudice to afford plaintiffs an opportunity to amend to address any perceived defect. Respectfully request this court deny motion to dismiss with prejudice in its entirety. And their certificate of service. Oh, yeah. Okay, so the person who wrote the motion to dismiss, is Anthony Dean Johnson, Senior Assistant Attorney General. You just dumb. Florida, what the actual are you doing? Your Senior Assistant Attorney General cannot remember to attach motions. Either that or attach exhibits to a motion. Either that or he knew those exhibits were complete and total bullshit and would not have proved his point. So either 3 reasons. Didn't think that they would prove his point, so he didn't admit them. 2, he thought he didn't have to because he's the Senior Assistant Attorney General and he thought he was better than that, or he thought he was above having to do that. Or 3, he's just plain fucking stupid. It could be a combination of all 3. It could just be the 3rd one. And you. Thanks for the $5 super chat. 12B6. Red crayon emojis. This is the one time when I won't make fun of you today because we're on the same team. Like, dude actually argued a point that contradicts the AG's own directive. Silly boy. Yeah, it's just. This is written by Randy or Randy's office, and it's a well thought out and well executed legal argument. For those on the other side that challenge his credentials, they're just dumb. Yeah. And I don't necessarily like everything that Randy writes, and that's one of the reasons that when I see when I see a motion that I like, I'm not afraid to point it out. because of the fact that I also point out when I see things I don't like. I don't just and that's how you know I'm telling the truth when I like a motion, because I'm not afraid to tell you when I don't like something. However, what we are going to do is we are going to, and thanks for the 136 people who have stuck it out with me. We are going to look up on Pacer. We are going to look up that case from Levy County in May. So I am on Pacer right now. I am not going to completely show you until I have the document. But what was that case number? Northern District of Florida. It was this. New search, case number. We're gonna go with that. Let's see if this gets us anywhere. An invalid case number. I think I had 25. What was the name on that? Does anybody remember the name on that case? Tyler versus Levy County? Let's see. We're just gonna do party search. Let's see if this is a Levy County Sheriff. Holy goodness. All right, I am gonna share this though, because y'all. Send cash. Yeah, that search cost me 10 cents. So you can see what I basically build. So Taylor versus Levy County Sheriffs. It's not closed yet. This one right here, we're gonna save that one. I don't have anything to is there any other ones that we think we should Cook v. Levy County, Roland Bell, did he do 2021? Oh, that's does anybody know if Scott Stark the does anybody know if Scott Stark where his law office was? Because there is a couple of things here, Stark v. U.S. and Stark v. Levy County, that I'm like interested, but I don't, that could be anybody. And I don't want to click on it because it's a use of force and official misconduct. Ooh, 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 ooh. St. Pete. Okay, because I'm just curious because there's one from Richardson Ross v. Levy County Sheriffs from 2007. Stark v. Levy County Commission, 2017. Stark v. Levy County, Florida, 2017. I believe the omission was deliberate to muddy the waters and slow things down to give Owen more time. I believe Owens will be kicked to the curb. You know, I don't necessarily disagree with you. I'm gonna hide this just for a second to just to make sure I don't dox myself. Because I am gonna click on this Stark v. Levy County, Florida. Case summary. Closed. Oh, Jeffree Stark. I don't know who that is, so we're just not going to, we're not gonna get into that one because I don't know who that is, and I really don't want to, put anybody's stuff out there that for just random reasons. Because we just aren't. I'm not that kind of person. Let's see. Yeah, now's the time to send them super chats because we're about to spend some cash. Like, uh, do. Okay, share this tab instead. Add a stage. There we go. Woohoo! I successfully did not screw that up. Excuse me. Dana Taylor. Do. All right, this is the violation of civil rights. I mean, mandate of U.S.C. Notice of appeal. This appeal is dismissed. The appellant, Diana Doreen Taylor, failed to pay the filing and docket fees to the district court. Yeah. This was Judge Cannon. Discovery due by 2/6/26. Motions to be filed by 6/1/26. Mediation to take place by 6/26/26. I mean, there's always that. Thanks. It was more of a where are things located? Because just where are people's offices located? What county? Because I don't know where certain things are. Yeah. So we can always keep an eye on this case because this is against Levy County. We can read the if you want on another stream, we can go through and read the we can read the see, look, motion to dismiss for failure to state a claim. Like, shocker, right? Like, this seems to be a motion to dismiss for failure to state a claim. Like, it's it seems to be the go-to for the motion to dismiss. Let's see. 42 pages. The complaint, amended complaint. Is gonna be selected. See, that's what I get charged. So I'm transparent with y'all. You think they send all the sheriffs to Levy County because they can't get a job anywhere else? Probably. I wouldn't doubt it. I would not doubt it. So we are going to just run over this like super quick, and then see, there we go, $4.20. So like I said, I'm transparent with you guys on where my money goes. So now I have to view the document because I already paid the money. So we's gonna. There we go. Notice of removal. Procedural allegations. Circuit civil complaint. Police misconduct, excessive and abusive use of force, abuse of power, false arrest and imprisonment, falsifying a police report, falsifying and inflating arrest charges, refusal of medical attention, failure to investigate complaints on scene, failure to have body-worn microphones active, traumatic mental and physical stress caused to the plaintiff. Plaintiff's inability to continue in her career field. I mean, do we know if does to the people who watch Jeremy Hale's constantly, yes, save document. Yes. Yes. Um Saving document now. What document is this? 31825. 18. This is document 1. This is complete. I am saving this to a new folder from Levy County. I am putting actually, we're going to do freak of nature. I have in my federal folder, I have Justin Kagenbauer, U.S.V. Hannah Dugan, Blake Lively, Blue Angels lawsuit, Brigada v. U.S., Jaden Rashada, the Ruby Frankie, U.S.V. Epstein, and the U.S.V. Comey, which isn't going anywhere. But with all that being said, we're going to start a new folder in there that's Taylor v. Levy County. Because if we will do a stream probably Monday, if no other documents in this case come out, we'll do a stream on Monday seeing what this is about and what other crap we can dig up on Levy County Sheriff's Office. Because, I yep. And Annie, thank you for the $20 super chat. Damn it, Pacer. Like, yeah, well, thank you for the $5 super chat. Blue Angels better watch out. The lady and her cat. There has been. I checked that docket the other day. They haven't even been served yet. So that it's. I think it was June or July. July that the lawsuit was filed. There has been nothing. That has gone nowhere. I'm wondering why it hasn't been dismissed yet. So. Mm. Hey, it's me. Hello, Squid. Any idea why people watch but don't hit the like button? Kind of like a tip jar. Because people are mean. Not everybody. Sometimes people just forget. But if people could, that would be great. That would be awesome. Let's go to see if my YouTube studio is fixed. I am pretty sure there's a public video of that specific stop from Sheriff Deathcan. I do remember seeing it story on the news locally. I will have to look into that because totally yeah, but you're a butthead, so there's that. Let's see. But this is where I'm going to stop today because I will cut this part out and make it a short and a teaser for Monday. However, thank you to the 111 people who hit the like button. I appreciate you guys so very, very much. There's 124 of you here and 111 people, so the odds are good. We did pretty well. I can't complain. Let's see. I'm going to see. That was very enlightening. That's a very enlightening stream. Very well written. Like, we made it through 26 pages of a motion in an hour and a half. Like, tell me how 0 as of now. But there's always going to be 2. There's always going to be 2 because I know who they are. Like, it is what it is. And I didn't have it on subscribers only mode either, so there's that. I probably should have, but I'm nice. But I am going to redirect y'all over to Shizzy this afternoon. He's talking more Hales stuff. I'm not sure what. But tell him I said go Navy, beat Army, because he ignored me last night. Making my view count. Thank you. Fucking order. He meant FOIA. Jesus. Y'all have a great day. I will see you tomorrow night, 7 o'clock on my other channel, I am going to be doing, we just do about 45 minutes talking about the latest video that we dropped over there on Thursday. If you haven't checked out my other channel, please do. That is my heart and soul, my baby, and I really want to get that channel up and running and try to get over 1,000 subscribers by, I would say, summer of next year. Hopefully we can do that. We're up to like 226 right now. We're not doing too bad, but we're at 226 on my other account. So we're not doing too bad. It's I will be dropping a short over there every Tuesday called Movement Minutes, to kind of get people up and moving again. Modifications always encouraged. But I will see you guys over. I said it backwards. What did I say backwards? I love this chat. Best chat in the world. Yes, this chat is awesome. All right. Y'all have a great day. Roy, I don't know what I said backwards. You know, am I by chance watching football today? Yes, I am. That's why we did the stream at like 12:30 and we did not do it any later because I will not be able to taking a what the hell's break today, mostly rewatching Game of Thrones. I have never seen a Game of Thrones episode in my life. But y'all have a great day, and I will see you guys tomorrow night on my other channel. Please join me over there. It's a fun community. It's a very tight-knit and no judgment community over there. We're over here, we judge. Over there, we don't. Y'all have a great night. Bye.